what happens when a missed court date, a delayed assessment, and a defendant who won't stop talking all collide in one courtroom? Today's case has everything: confusion, frustration, bond disputes, and a judge who has clearly reached their limit. Pay close attention, because what starts as a simple scheduling issue quickly turns into a lesson on courtroom consequences, accountability, and how quickly things can spiral when emotions take over.
Miss Lundy.
Good morning, Your Honor. Ashley Lundy for the people.
Folks, you're going to need to quiet down. Court calls case People versus Larzell, Washington.
Good morning, Edward something happened with Washington.
How you doing, Your Honor?
I'm doing great. What's your name?
Larzell in Washington.
Thank you.
Thank you, sir.
Your Honor, we had referred this over to the recovery court. I spoke with them and they indicated that they've in receipt of all the information to do an intake. However, they have not done that interview. That interview could be completed within the week. Like if we could have a 1-week adjournment.
Probable cause conference, May 22nd, 2025, 9 a.m. bound continue. Court calls case People versus Marquis Fab.
Oh, excuse me, sir.
Yeah.
Can I please have a word? With all due respect.
I think Mr. Washington would like to address bond.
Excuse me,
Go ahead.
how you doing, Your Honor? My
I'm
name is
great.
Larzell near Washington. First and foremost, forgive me about my outbreak last time I was here.
Can I have that file?
And thank
Go
you,
ahead.
sir. Thank you, sir. What happened was I wasn't aware, as my attorney indicated, what day was my probable cause hearing was. Okay, I went back to the magistrate. They said, no, well, we're gonna let Judge Simpson handle it. Then last time I came here, it was a 2-week hold because they didn't do their job. I feel I shouldn't have to be.
Who didn't do the job?
What you say? You gave him a plea.
The recovery court?
Well, I didn't ask for no recovery court, but whatever assessment you gave him, it was 2 weeks. And the honorable judge said, okay, well, I'm not going to change his bond. Now, you still didn't indicate I was looking for a bond. And I wasn't even aware of a drug court. So with all due respect, I do appreciate you, but I did, unfortunately, miss my court date.
Right.
I was.
And then how'd you come into custody?
Oh, I came into custody? What, trying to being a good Samaritan. Some woman was being stalked and they figured out what my name was. And I totally forgot. I really didn't know what court date it was. And I was disciplined for the first, and in the discipline, well, not necessarily discipline, you allowed it to, override until they took care of their own situation, but it's not my fault.
So who is they?
Would you explain to him?
Well, I think I got to collect more of that story.
Okay, you gave him a piece of paper about assessment along with a plea.
Mhm.
Okay, I get here today, the assessment got taken care of. Right?
You just want them to speed up the process.
No,
I think
not them. It's not his fault. He's a judge.
Mhm.
They supposed to be.
Thank you. That's right. Nothing is my fault.
No, yes, it's not.
That's right. I know.
Amen. So I'm saying, I'm just trying to, sir, live my life. I normally work the carnival shows. I have really been disciplined for not being aware of to show up. I'm not dumb enough not to show up again.
Excuse me one moment. Whose phone is that? It's somebody down there's phone. Is her? Tana's phone? Really? Go ahead, sir.
And I'm not ignorant enough not to show up in front of Judge Simpson courtroom again.
I think he is saying that he would show up to court next time. He's asking for a PR bond.
Yes, I am, sir.
If the court would not provide a PR bond at this time, if the court would allow an interview to take place, if that interview takes place, then the court provide a PR bond.
I never said that. I asked, could you please provide a PR bond? And I will.
I addressed this the last time you were here.
What was it about?
I think they're gonna keep you in.
All right, man, you're fired. God bless you. And thank you, Your Honor.
Why is he fired?
Because he's not speaking up for me. I really don't even know what's going on.
Oh, it would, okay, so did you understand before you make that final decision about firing him? It
Well,
wouldn't have mattered whether you spoke or he spoke. I'm denying your motion. I've already
okay.
heard it.
well, I don't know. Why are you denying the motion? And what's so funny?
Because
Wow.
because you appeared here, didn't show up, didn't turn yourself in, got picked up, got brought here.
Yes.
That's how we got you back.
And the
So I'm
magistrate,
not releasing you
right, the
now.
magistrate
Okay, so
did not release me, and then
that's right.
you didn't release me
That's
because
right.
you wait for assessment. Am I
And I
correct?
haven't had the assessment yet. Have I?
Exactly. So is it my fault you haven't had assessment? Is it your fault?
It's my fault? I thought nothing was my fault.
So whose fault is it?
I don't know.
But it's not mine. You do agree.
No, I don't agree.
The assessment, do I?
I don't know whose fault it is. It hasn't happened. I'm done.
Pretty much. God bless you.
Thank
And
you, Your
you.
Thank you, Your Honor.
Well, keep talking. Why are you up here at my, why are you at my podium? Why are you at my podium? Next time, Tana, turn your phone up louder when that's going on.
And then it was.
Did I call your case?
Yes, you did. You called, Mr. Babb, Marquis Babb.
Oh, that was so long ago. You're right. You are right, Miss Cannon. And I usually criticize you for not getting up here on time. And I have to give you credit that you're like early.
Got it, Judge.
Court calls the case, people of the state of Michigan versus Babb.
That is enough on behalf of the people, Your Honor.
Stephanie Cannon, on behalf of Mr. Babb, who should be appearing by Zoom. Oh, thank God. He's there.
Mr. Babb?
Please be there. Oh, what had happened?
Marquis Babb, you need to unmute and turn on your camera. Every week, Cannon. Every week.
I was doing my part today.
Never mind. I'm gonna say something. This is practicing law by janaza. That's what you're doing right now. This is
Great, he got it.
yes, I can relate. This is so you. You're like, what? Oh, uh-oh. Mr. Babb?
Yes, sir, Judge.
All right, you got your camera on?
You need the camera as well?
Yes, Mr. Babb.
All right. Ms. Harvey, can you state your name?
No, I can't. I know, you got, my last name, Michelle. Where are you? Where are you?
I met with you in jail yesterday.
Look, if it's gonna skip, okay, yeah, okay.
All right. You're Miss Harvey?
Yeah.
Okay. You're seeking an adjournment?
I am, Your Honor.
No, not you. I'm not Miss Harvey. People don't miss Harvey. I'm Harvey. I'm Harvey like that. People don't miss me, but I'm Harvey.
Okay,
Miss
so
Harvey,
that maybe she doesn't want to be addressed as a Mrs.
Understood.
I know miss. People don't misses me or nothing. I'm
Oh.
Harvey.
Sorry about that.
My apologies.
Okay.
Probable cause conference will be adjourned June 5th, 2025. 9 a.m. Bond continued.
We'll be in touch, Harvey, okay?
When?
I'll come visit
Excuse me,
you.
what's going on?
We just adjourned your case. Winona, remember we spoke yesterday and you said
Until when?
Which date did you get?
June 5th.
Thank you.
June
Sorry.
5th, you want to see me?
No, I'm going to see you before then.
Look, I'm not going back. I can't go back to the conference room. That hurt my back a lot. That room you took me in hurt my back a lot.
Okay. I'm gonna let you talk to your attorney some other place, okay?
Okay,
Thank you. Shut her, please.
This courtroom exchange highlights one of the most misunderstood aspects of the criminal justice system, the difference between procedural delays and personal responsibility. From the very beginning, this case revolves around a missed court appearance and an incomplete assessment tied to recovery court. Two issues that might sound minor on the surface, but carry serious legal. Mr. Washington repeatedly emphasizes that he did not understand his court date, that the recovery court assessment had not yet been completed, and that he believes none of this should be held against him. But here's the critical legal reality. Once a defendant is notified of a court obligation, whether directly or through counsel, the responsibility to appear does not disappear simply because there's confusion or dissatisfaction with the process. Okay. The judge makes this clear when addressing bond. The court isn't focused on intent or emotional explanations. It's focused on what happened. Mr. Washington failed to appear, did not voluntarily turn himself in, and was ultimately taken into custody. Those facts alone are enough to justify denying a personal recognizance bond. In courtroom terms, reliability matters more than explanations. Okay. We also see a textbook example of how excessive interruptions and emotional outbursts can hurt a defendant's position, while Mr. Washington repeatedly insists that delays are not his fault. The judge is weighing broader concerns, compliance, courtroom decorum, and whether the defendant can be trusted to follow court orders going forward. When a judge says, I'm done, that's not frustration, that's finality. One of the most striking moments comes when Mr. Washington fires his attorney mid-hearing. From a legal standpoint, this changes nothing. The judge clearly states that whether the attorney spoke or not, the ruling would have been the same. This reinforces an important takeaway. Judges rule on facts and procedure, not volume or passion. The later cases in the transcript, including Zoom delays, identity confusion, and adjournments, serve as a sharp contrast. They show how routine court proceedings can move efficiently when participants follow instructions and stay focused. Adjournments are granted quickly, communication is clear, and emotions remain controlled. That comparison makes Mr. Washington's earlier exchange stand out even more. So what's the bottom line? The court denied bond because the defendant failed to appear, had not completed the required assessment, and demonstrated behavior that raised concerns about compliance. Whether the delay in assessment was his fault or not became legally irrelevant once those factors were established. Yeah. This case is a powerful reminder that courtrooms operate on structure, not sympathy. Judges may listen, but they ultimately rule based on actions, timelines, and responsibility, not explanations delivered after the fact. Now, Here's the real question for you. Do you think the judge made the right call denying bond, or should the delayed assessment have been taken into consideration, have ruled differently? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. These cases unfold every day, and we're here to break down what really happens when the gavel comes down